G'day, welcome to the Financial Bloke Podcast, the podcast for people seeking the wisdom needed to grow their family's wealth and live a happier, healthier and more prosperous life. My name's Ben Law and I am the Financial Bloke. Most rural producers have legal and tax structures in place like partnerships, companies and trust. Most are put in place for either tax planning or asset protection purposes, but they're often ignored or misunderstood because my accountant deals with that sort of stuff. Few producers really understand them, and few understand what can go wrong if they or their accountant are not all over the legal and tax requirements. Our guest today is Kylie Wilson, who I had on from episode number 17. Kylie is a lawyer who has specialised in advising families in the rural space for well over 20 years now. She's a partner at Holding Redlich with offices in Melbourne, Canberra, Sydney, Brisbane and Cairns. Kylie's a sought-after keynote speaker and she's technically exceptional in the areas of estates, tax, succession and self-managed super funds. She's also one of those professionals who really cares about her clients. Now, before we start, we've got to keep the pesky lawyers happy with a disclaimer. So here we go. The information contained in this podcast is general in nature and for education purposes only. It's not financial advice, it's not legal advice. You should not act on the information without appropriate specific advice for your particular circumstances. I'm a former financial advisor but choose to no longer be licensed and cannot and will not give you specific or personal advice in this podcast. So now that the lawyers are happy, I just want to say, welcome back, Kylie.
Thanks for having me again, Ben.
Now, it's great to have you back, especially after the hugely popular episode we did a few months ago. Now, if anyone listening hasn't heard it, I'd recommend you go back and have a listen. It was episode number 17, and it was titled, Avoid One Common Way Families Lose Their Farm. Now, Kylie, I reckon you got a fair bit of positive feedback from the episode. Was that the case?
It was, Ben, and it's good because it's great to see the education getting out in this area, so that your listeners can stay informed both about issues in agriculture and in the law, because I think having just that basic starting point to then be able to go and get further advice is just so necessary. Yeah,
I think it is. And you know, there's got to be a certain amount of knowledge that you do have to make sure that you're abreast of any of the complexities that are involved. So now I'm a big fan of the KISS principle, which is keep it simple, stupid. And I try and do everything like that, keep it as simple as you possibly can. But the fact is, if you want to be successful, you sometimes need to understand the complexity of some key topics. And one of those is asset protection and tax. And it isn't enough just to say, you know, I pay my accountant to deal with that. I reckon you need to have some level of understanding. Now, most rural producers will have something like a partnership, a company, a trust, or a combination of all three, and they've usually been put in place by their accountant for either tax or asset protection purposes. Now, Kylie, can we kick off with starting a couple of minutes briefly outlining for everyone why you should know what partnerships are, what companies are, and what trusts are, and how they work?
Yeah, look, it's important because, as you say, in family business across the board, whether it's in agriculture or not, you've normally got one or more of these structures in place. And most of the times where I see problems, issues, disputes in particular pop up because people don't necessarily have enough of an in-depth understanding of what's actually sitting within their business. So a bit of a 101 on these structures never hurts. And you know, we've only got time today to do these in particular at a fairly high level. So I'll just point out some of the issues that we see in particular. So partnerships are important and they're very common, particularly in agriculture. They generally have two or more individuals in partnership together, but there can be other structures within as a partner in the partnership, like a discretionary trust. So we sometimes see a couple of discretionary trusts as partners in a partnership. What's really important to understand from an asset protection perspective is if you have farming land, for example, in your personal name, and you are then an individual in a partnership that's carrying on the business, and the business is successfully sued, your land's exposed. Because partners are jointly and severally liable, which means if you're an individual, your own personal assets are going to be dragged in to satisfy any judgment that might be taken against the business. So there isn't really a lot of asset protection as far as a partnership structure is concerned. There are some tax advantages, particularly in agriculture with partnerships, which is why we see them so commonly in agriculture. So what we tend to say to clients is, look, have a really good understanding of why you've got the partnership, what your concerns might be, because sometimes it's a commercial decision about what's more important to the individuals or whoever's in the business, is it tax or is it asset protection? Because partnerships don't always satisfy both issues. So sometimes they've got to have a think about that and look at that as a priority. Now, some of the other things that need to be taken into account with partnerships are, let's say we've got mum and dad in a partnership together and sons in the partnership as well. And I've had one of these recently that's been fairly traumatic for the entire family. And dad passes away, mum passes away 6 months later. The land is held in mum and dad's personal names. The children off farm file a family provision application to essentially go after the land. But what no one's really thought about in that context is, and this one happens to be in New South Wales, but Queensland's the same, automatically under the Partnership Act, if there's no partnership agreement, the partnership has to dissolve on the death of one partner. And what that means is that that partner's share of the partnership actually is an estate asset, which is then available in respect of that family provision application. That wasn't dealt with in this particular case for about 4 years down the track until the land had been dealt with. And by that point in time, you've got a whole bunch of taxation issues sitting in there because the partnership hadn't been dissolved way back when. And everyone has to look at how we tidy this thing up. A simple partnership agreement that deals with that provision in the Act can actually help overcome those problems. So understanding what you've got, what's in there, do you need to have an agreement to deal with how the partners deal with each other, but also what happens if one of those partners has a total and permanent disability or passes away, particularly passing away and the thing dissolving where that might not have actually been the intention. So fairly important from that perspective. The 101 high level with partnerships would be, one, do I have a partnership agreement? Because if you don't, even if it's just mum and dad, you actually might need one because there may be a problem if one of you passes away.
Which is a major problem, isn't it?
It can be, depending what's in the partnership, yeah.
And the other thing, Kylie, is the fact that if you see I see a lot of them where they're in partnership with their brother. You see a lot of that where dad's in partnership with his brother as a family historical legacy, and then something happens in the family there that's even more difficult.
Or uncles and nephews or aunts and all members of the family can end up. I've seen some where we've got 5 different members of the family in a 5-way partnership and no partnership agreement. So you've then got to take into account things like, and we'll talk about that in respect of companies as well, do I actually want to be in business with this person's spouse? So that's a fundamental issue in agreements that needs to be thought about, but also from the perspective of what happens when someone passes away. And partnerships can be particularly problematic in that area because from an accounting perspective, it's not that easy to necessarily dissolve them quickly. And I'll often see these things in estates have carried on with the, in inverted commas, estate still being a partner in the partnership, when in fact at law, that partnership dissolved back when mum passed away.
Today's episode is brought to you by AgriCoach. You've worked bloody hard over the years and you've built a solid operation. But as your children grow up and start their own journeys, you're beginning to think about the next 5, 10, and even 15 years and how to keep driving the business forward and ensure a smooth and successful succession plan. Preparing the business, preparing the next generation, and preparing for your eventual retirement all requires a solid plan and a proven process. Unsure about the right steps to take? Head on over to agricoach.com.au/webinar to learn more about our Succession Proof Your Family webinar. AgriCoach, aligning families, growing wealth, and protecting legacies. And now, let's get back to the episode. So it can trigger a lot of unnecessary tax implications as well.
Yeah, and it's messy. So understanding whether you should have a partnership agreement and actually having one. There is very few circumstances where you shouldn't have one. And secondly, do I need to consider the asset protection problem? So how exposed am I?
Yeah. So, Kylie, how many people would come to you as a new client, say in the ag space, and they have a partnership and you have a look whether they've got a partnership agreement? How many would actually have them in place, even if they're obsolete?
About 5%.
Yeah.
Yep. 95% of the clients I see who have partnerships in agriculture don't have a partnership agreement. Look, it's a very simple document and not a very expensive one, but can save it. We call it a cheap insurance policy. It can save a lot of problems down the track, particularly if there's a dispute. So that's some are just the main things to think about. There are a whole bunch of issues in partnerships, but they're the main things to think about at a high level. Companies are becoming more and more popular in family business. There's a few reasons for that. They're recognised worldwide as a business structure. The companies have advantageous tax rates in Australia that are only going to probably get a bit more advantageous. And thirdly, from an asset protection perspective, the company's assets are separated from your individual assets. So if the business in the company is at risk, your personal assets aren't necessarily at risk, subject to some things like directors' liabilities if you're a director of that company and it's trading insolvent and a few other bits and pieces. So you've got to keep that in mind with them. A couple of things that you do have to consider with companies, again at a high level. When they're set up initially, I see a lot of companies in family businesses that are set up with mum and dad owning the shares in their personal names. That can create a whole range of issues down the track. One can be, for example, let's say we've issued shares at $1, mum and dad own those shares, and down the track they actually want to move those for, might be asset protection and tax reasons, into something like a discretionary trust. They're being transferred. And that's a market value substitution at that point, even though no money is changing hands. So if the share was issued at $1, but the company now has $500,000 worth of assets, like cattle, for example.
Or machinery.
Yep, or whatever's sitting in there, you've suddenly got more or less a $500,000 gain that's taxable, where you don't actually have any money to pay that tax if you're restructuring or moving it. So you've then got to look at complicated things like rollovers, etc., as to whether you can restructure. Where if you're thinking a bit more long-term when you set it up, you can think about those issues. You should also be thinking about shareholders' agreements, the same as we talk about partnership agreements. So for a couple of reasons. One is, again, if they're in individual names, that share is going to be an asset of the estate. So what's actually happening in the will as far as where that share is going? And is that those shareholders going to control that company? Is that actually where you think the control of that company is supposed to sit from the other shareholders' perspective? Some of that can be dealt with a shareholders agreement, particularly if there's succession provisions in there so that people have actually thought about what happens if a shareholder passes away, or even if it's a trust that owns the share, what happens if the control of the trust changes, that type of thing. And we often see shareholders agreements, and look, this doesn't matter whether it's family or not, we'll often see shareholders agreements that haven't gone into that level because people are thinking about the business when they do the shareholders agreement, but not necessarily thinking about what happens if a main person in the business who also owns the shares passes away or has a total and permanent disability. What's going to happen at that point? So thinking about those things when you're getting advice to say, look, you want to set up this for your business, it gives you asset protection, everyone knows how a company works, this might be a great idea. What are the longer term implications? Because down the track, it can be a lot more expensive to fix than setting it up right in the first place.
There's also some capital gains tax issues, which we don't need to go into today, that are a little bit more complicated when it comes to companies, isn't there?
Correct. Yeah. So some of the concessions you won't get at a company level, for example, which you might get if you're individuals or even in a trust. So having advice at that point when you set it up, again, can be a cheap insurance policy, because normally that sort of advice on setup is relatively minimal, whereas advice on having to restructure your business is a lot more complex and, again, relatedly more expensive.
Yeah, without a doubt. And I think also too, Kylie, what a lot of people fall into just before we duck into trusts is the fact that quite often people have multiple entities. So they might have a partnership that has been there historically and is still running in the background because it can't be closed down apparently for certain tax reasons. Then they might have a company and a trust or multiple companies and trusts.
And you then end up with you can often end up with related loan problems too. So if you're trying to unwind, particularly from a succession perspective, if you're trying to unwind some of these structures for the next generation, you can really delve into some issues, and we'll talk about that in trust as well, and some problems in respect of which entity has loaned which entity what money, where does that fund flow actually end up, what's sitting in the balance sheets, who can call on what. And where you have company over here, partnership over here, another company where the shares are owned by trusts, maybe a beneficiary company down the bottom as well, and you can see some fund flows that might have been done for tax reasons because that was the best way to deal with a tax problem at a particular point in time. But at law, those loans can be payable on call. So who actually controls calling for those loans? Because your assets may not actually sit where you think they sit, depending on what those loans are. So understanding what's sitting in your financials when you have structures is very important from a long-term perspective. So yes, the tax is important. And look, all regional accountants are fantastic on, making sure that their clients understand their tax position and have the best approach and all across the best things for primary producers, and they're very, very good at it. Sometimes the long-term things get missed for a whole range of reasons. And it's worth a review at least every 5 years. Okay, what's sitting in these financial statements? Do we need to tidy up at some point? And you can talk to your accountant about that because that's just part of long-term tax planning anyway.
It is. And I think also too, Kylie, a red flag for me was always when I'll speak to clients about their balance sheet over the years and there's loans, intercompany loans or intertrust or beneficiary loans, etc., which again, we won't have time to get into. But then the statement is it's just on paper. And I think, and it's just been put on paper, it's just a paper entry, don't worry about it. Oh, that's a huge red flag for me because just because it's on paper doesn't mean it's not real.
Yeah, yeah, that's right. Yeah. So the problem with that is, and there are some complex legal arguments in respect of what's a loan and what isn't a loan, but frequently if you've got, particularly in trusts, a beneficiary account where someone is owed money from the trust, they can call for that money to be paid to them. And I had one which you're familiar with a number of years ago where the son had been running the business in a trust entity for a long period of time, but didn't control the trust. And the wage that he'd been paid by the trustee had been recorded as a loan to his beneficiary account, as in he owed the trust that money. So he'd basically worked for 25 years for nothing. And when his brothers took control of that trust, they called for that loan to be repaid by him. So understanding what's sitting in those financials, if there's any prospect down the track of there being any sort of dispute with the family or the business, is really important.
Yep. And I think that point you made about reviewing it every 5 years, it's like decluttering your house. We always find things just build up, and then every now and then you just got to go and have a dirty, great big clean up. And I think it's the same with your financials.
Oh, and we see structures grow like mushrooms. So, some of the flow charts of structures I see look like a mushroom. And the clients will often not know why they've got that sitting there, which is, and why it's important for advisors as well. This always has to be a teamwork approach. So whenever you're looking about long-term planning for the business or the family or estate planning, etc., it's important the accountant's involved as well, so everyone can be on top of who controls what, where's it going, why is it going there, all of that sort of thing.
And it's interesting, Kylie, a lot of the feedback I've got on the podcast is there's a lot of accountants listening, which is really nice. And what I want to say is that one of the things that I've found really valuable from people over the years from producers is the fact they don't understand the entities. It's been explained to them many times, but they still don't actually get it, is that entity diagram is such an important tool to be able to bring out, give the client, they can take it away, they can refer to it. And once they've got that entity diagram, it makes such a big difference.
And it's a lot simpler.
It is. Well, it's a visual and you get to understand the where the arrows go and the interflows and who are the responsible people. And then over time, it becomes such a valuable tool.
Well, and it's important for people to understand that advisors, accountants, lawyers, whoever, we don't have a crystal ball as well. So a lot of these clients will have had structures set up because their particular situation with their business at that particular point in time, with the tax environment at that time, or whatever the asset protection risks were, that was what was perfect for them then. Just because 10 years later that's not perfect anymore doesn't mean the advisor did anything wrong. It means that it hasn't been reviewed and checked progressively over time to be kept up to date with what's happening in the family and the business.
And also, two things just become more important as time goes on. Like originally, it could be a little bit of an issue when you look at it with your professional advisor and they go, look, this isn't that big an issue. It's an issue, but there's some other factors here which would mean that making a change doesn't make sense. 2 years down the track, there could be some tax law come through or some case law come through that all of a sudden saying, hey, we didn't say it was that big of an issue before, but I think it's getting to the point now, or your circumstances have changed, succession, retirement, all those sorts of things, which would trigger us to go, now this review is more important.
More children, grandchildren, all of that.
Absolutely.
Yeah. So, circumstances change and you need to have a revisit of what you've got and why it's there and does it actually suit your circumstances still.
And do you get it?
Most of the time it will. Sometimes it won't.
Now, if we go on to trusts, and this is the one we really wanted, and you actually reached out to me and said, this is a topic, Ben, I think we should have a discussion about, and I thought it was really important. So the next part is trusts, for you to go through that. But I know there's been some changes to, and I'm going to say trust law, but I think that's probably technically incorrect, but there's been some changes to trusts.
And it's still evolving too. I mean, I think we'd call 2022, I would call it a year of correction as far as trusts are concerned, because from at least purely a legal perspective, it's important for people to understand nothing significant has actually changed. What has happened is there have been some cases which have illustrated the risk of not dealing with your trust appropriately.
And that's an important word, appropriately, isn't it?
Yeah, that's right. So it's important for clients to understand and listeners to understand that trusts are a separate legal entity. So we have a lot of what we'd call mum and dad trusts. We've only had this pure discretionary trust type structure in Queensland since 1973. So we are starting to see a number of the problems because we've had very big wealth developing generation in the baby boomers, a lot of whom have had trusts, but we have a lot of situations where we have large value trusts that were established by mum and dad that have every member of the family, including aunts, sometimes cousins, every company and trust structure of which any of those people are also shareholders or beneficiaries of that are also beneficiaries of that trust. So you can have, and there are reasons for it, but you can have a big group of beneficiaries. Now, there's a couple of problems that have arisen. Probably what I'll step back a moment and just give a very brief 101 on trust structures.
Just for anyone listening, I hear this all the time. Someone says, I'm running a company and I think I've got a trust. This is going to be important to you anyhow, because quite often what you'll find is you might have ABC Farming Proprietary Limited as trustee for the ABC Farming Trust. That means you've generally got a trust. So if there's any...
You've actually got a trust, not a company.
Not a company. Yeah. So you're actually not operating a company, you're operating a trust. So don't just zone out because you go, I operate out of a company. This could be really important for you. And also this could be really important if your accountant recommends some changes in the future that you understand how this works. So sorry, Kylie, back to you.
Well, yeah, and in addition to that, keep in mind that if you have got a company and it is actually a company, there's every chance the shares are owned by a discretionary trust or trustee of a discretionary trust. So you're right. I see multiple clients who say, I am this company, but that company is trustee of a trust with the same name. And the best way to think about it is the assets sit in this trust structure. The trustee sits up here. And the trustee, if that's a company or it can be individuals, makes the day-to-day decisions about what happens with those assets. Your actual control of a trust, though, will normally sit in the trust deed with someone called the appointor, guardian, or principal. So who is named as that in the trust deed is actually really important because they're the person who can sack the trustee.
They're the god of the trust.
So your fundamental control of the trust assets is actually down here, not up here. And a lot of people miss that step. And it's important for a whole range of reasons, but also for if something happens to that appointor, who actually controls those assets? Because they can change the trustee at that point and put in place whoever they like, possibly, depending on the terms. So it's important thinking about that we can't determine any of that if we don't have a trust deed. And I deal a lot with clients where we've got a trust deed where it's not an original or it's just a copy, and they can't find an original, or they can't find the trust deed at all. Now, that's very problematic because we don't have a register for trusts. So there's a bit of a process you have to go through to try and figure out, do we have a trust? do we actually have a trust? Is there a trust deed? What are the records? Sometimes we have to go to court to get declarations that there was a trust just to protect the client from what they might have done on the basis they were acting as trustee. We can't necessarily prove that point with no deed. And trust can be amended. So you need to know where's your trust deed and where are all the amendments to that trust deed, first and foremost, because looking into these things becomes pretty impossible if you can't look at the deed, because the deed indicates what the trustee can or can't do for the most part. There is a Trust Act which applies as well, but the deed's incredibly important. So where we've seen problems is with these mum and dad trusts, where people have been treating the trust assets and the trust bank account like it's their own bank account. So it's important for people to understand, as I said at the start, it's a separate legal entity. And if you control the trustee, if it's a company, or you are the trustee, if you're an individual, you have duties as trustee. They are fiduciary duties, which means they're significant and they're important. So you've made a choice to be the trustee of that trust when you signed the deed when it was originally established. You are then obligated to comply with your duties. And one of the ones that's become a problem and a risk with trusts, particularly over the last couple of years, is when the trustee makes a decision to who's going to get the income earned on the trust assets in any particular year. Have they actually exercised good faith and real and genuine consideration when they decide which beneficiaries are receiving what? So we're seeing a bit of a risk arise with this broad class of beneficiaries because trustees actually have to consider every beneficiary when they decide to exercise their discretion about what they're paying to who. And often that doesn't happen. So there was a very relatively high-profile case last year in the Victorian Supreme Court where, just to put it simply, because of the time involved, let's think about it from the perspective of we've got mum and dad who've been trustee of this trust or controlled a corporate trustee. They've been paying income out over a number of years, either to themselves or one of the children, or between themselves and one of the children, but not to two other children. The two other children challenged the exercise of that discretion and were successful in having an independent trustee appointed because the trustee had never considered their circumstances in making decisions about making distributions.
So did they sack mum and dad, essentially?
Yeah, mum and dad weren't around anymore, but the person who'd stepped in mum and dad's place was sacked,
Wow.
yes.
So they lost control of those assets.
They lost control of those assets. Also expensive because if you're having an independent trustee appointed, it's usually a professional. So you're actually paying that trustee for complying with their duties because they are onerous duties to do that. That's not new law. So there's been a bit of hoo-ha about this case because it also applied to a self-managed superannuation fund. There was a previous case that dealt with this issue. It's also a trust. People don't think of their SMSFs as trusts, but they actually are. Similar principles apply. So it isn't new law. It's been sitting around for, it's a very well-known High Court case in 2010. There's another very well-known case called Carger and Paul way back in 84 that dealt with this issue that's always referred to when the courts have a look at it. Fundamentally, at a high level, you need to think every year when you're making distributions of income, who are your beneficiaries and why are you or aren't you distributing to them? Because if someone's a beneficiary of that trust and challenges it later, there are some downsides. It's not like a family provision application where they may be pretty sure they're going to get paid something extra out of the estate. What they're actually trying to do is put in someone independent in place so that they get considered. That case I talked about, the assets of that trust were about $23 million. So there was something to fight about. But in agriculture in particular, we've seen over time land also end up in trusts, and obviously agricultural land is very high value. And if you've got all your children, as well as nieces and nephews, as well as brothers and sisters, all as beneficiaries of that trust that owns all that land, you may have a risk. So understanding what's actually in your trust deed and do you need to review that? Do you need to correct it? There can be amendments made. You've got to be a little bit careful that we don't trigger any tax or duty problems, but you can amend it. Do we need to look at that if we've got too broad a class there or there's some risk down the track? So that particular issue has been a very live one over the last 12 months from a particularly asset protection perspective. understanding you've got obligations and duties as trustee. Now, I say this in the context of it doesn't necessarily mean that a trust is not right for you, because there are asset protection advantages with a trust. So if you've got land in your personal name and you want a really simple structure to run your business, relatively simple structure other than what I've just said, you might have a trust that's running your business and your land's separate. Business suit over here, trust separate legal entity, land is protected over here. So there are still advantages for asset protection. You still have the ability to look at broadly how you're dealing with the income each year between the beneficiaries. So you've got a broader scope for spreading out your income, etc. Those things are all still there. But you do have to turn your mind to, if it was set up in 1984, who controls it now? And are all the beneficiaries named in that deed still people we want to be beneficiaries? Because that's, again, we come back to let's look at it. Does it still suit your circumstances or not? The other issue that's popped up and been very live and is still evolving is Section 100A. So effectively, the ATO has said that if you are making distributions from a trust, which in their view, when you've made those distributions, you're only seeking tax advantages in doing so, you might have a problem in that respect. So prime example is mum and dad control the trust. They have said, adult child over here, we're giving them all of the distributions from the trust this year because they don't have a job, but we're not actually giving them the money. We're keeping the money ourselves and we're just recording that in the financials. That's a problem because they've only done that for the purposes of saving tax. So it's a fairly complex area. I won't go into it in a lot of detail, and there is currently a case that we've run that's on appeal, and we're waiting on that appeal to be handed down about the ATO's approach in a particular case. What the ATO has said, it will depend on the facts in any particular circumstance. So if you have a genuine family arrangement and it's an ordinary commercial dealing with the family, what does that mean is what you've got to think about, and have you actually made your distributions appropriately? So there are plenty of circumstances where you'll be making distributions to adult children where they'll actually be receiving the funds and using them for their own benefit. That's fine. It's where you're only doing it to save yourself tax and you're actually keeping the advantage of receiving the funds. You're going to have to think about that a little bit differently, or the trusts retaining the funds. You're going to have to think about that a little bit differently. And again, it's just treating the trust like a trust. So understanding what that means and what trust entities are, what you need to think about when you're making distributions on a yearly basis, who the beneficiaries are, all of those sort of things feed into is why I call it a correction year, as far as none of this is predominantly new. It is literally the court saying, we're reminding mum and dads that they've got trust duties, and the ATO saying, we're reminding people that when you have trusts, you actually have to be making your distributions appropriately and paying them out where they should be going. That's always been the case. The ATO has taken that a little bit of a step further, which is still an area of law that remains to be settled, as I've said on appeal. But at a high level, it doesn't necessarily mean that you shouldn't be using a trust, because it doesn't mean the landscape has significantly changed. It just means that you actually have to be very conscious about what you're doing when you use that trust, as you should always have been when the trust was originally set up. So still advantages because they're fairly flexible and provide asset protection, but know what you're doing and know who your beneficiaries are in particular. Understand who's the appointor, understand who the trustee is, understand why you have these structures, whether that's a trust or a company or a partnership. As you said, the flowcharts are great because you can easily identify this company does this company does that, that trust has these beneficiaries, this is the appointor, this is the trustee. Makes it a lot simpler than peeling through a 50-page trust deed, figuring out who has what power and who does what. you should do that anyway, but not necessarily yourself.
I appreciate that. And the two things really that came out of that, and correct me if I'm wrong, is one is making sure you have your trust deed and it's up to date, because obviously things change. And also too, we've reviewed some trust deeds I had you to do over the years, Kylie, and just mistakes are made and things like that in them and need to be corrected from trusts from way back. But also too, just making sure when you do your tax planning at the end of the year and you do distribution statements, etc., where the money is being distributed for tax planning, that you actually give it due assessment of the genuine and due care.
Think of it as genuine consideration, good faith and real and genuine consideration. So what that looks like, there are a number of cases that have identified what that looks like. Realistically, it's the trustee applying their mind to why they were aren't doing and actually documenting that. So make sure that the trustee is documented, not just I'm going to give 100% over here. Why am I giving 100% over here? And is there a reason there might be other beneficiaries that the trustee should be considering because they've got problem financial circumstances, for example? Then you really need to say why it is that money's not going there, because the trustee has duties to those beneficiaries impartially. So subject to the trustee, of course, but fundamentally, if you've got a number of beneficiaries and you've got a discretion as between all of those beneficiaries, if you are prioritising one over another, unless the trustee tells you have to, if that's purely discretionary, why are you doing that?
Yeah, that makes perfect sense. And I think, Kylie, we talked about also the fact that people, if someone's in a position like this where they're sitting there going, geez, I've got a trust, I think I've got a trust. The first thing is what can they do? And two, the natural reaction from professional advisors when these things change is a knee-jerk reaction. We need to get rid of the trust. We need to get a company. This is the new thing, and that may not always be the case. So what can producers do when they either know they have a trust or they are being told they need to get rid of the trust?
It's basically it's get advice, but it's, so if we're looking at, are we checking what is in the trust deed? It's a very simple review. So it normally needs the trust deed and a copy of the most recent financials so you can see what's happening in the loans, because as we said before, if the loans have been building up over years, where are the assets actually going? So you might think that you can pass control of this trust to child number one over here, but in fact, child number two is owed $2 million. So your assets are actually sitting with child number two if he calls on that loan, for example. So that's why a review of the financials is important as review of the trust deed. If you're getting advice to change things, it might be valid advice, or it might be, do we need to look at a bigger picture approach? So what's the reason for the change? What are the costs of the change? Is there tax and duty consequences of the change? Is there a reason for that? Or is it just we're worried that trusts have reached their use-by date? Because if it's just trusts have reached their use-by date, trusts haven't reached their use-by date. But if it is we have a client that absolutely can't manage their trustee duties, that's a different issue. So the trust might not be appropriate for them. You need to understand the why.
So that's something you do. Like obviously you get people come to you saying, hey, we need either a second opinion or we need the advice around this side of things, because you need a specialist, either tax lawyer or specialist accountant that knows this area intimately to be able to go through and review it and not look at just that one specific issue. It's how it ties into everything else.
They're global issues, so it's why I talk about teamwork, because the accountants will be really on top of a lot of the tax issues that sit within this, but they won't necessarily be dealing all the time with the disputes.
Yes, yeah, which is important.
So if we're looking at what's in there from a dispute perspective, so if we're getting recommended a company and moving away from a trust, how are the shares going to sit? Is that going to lead to bigger disputes down the track than the trust did or not? All of those type of things. It's global, particularly in family business, because it's not just about tax. So yes, the tax is important, but if it's an intergenerational family business, we've got to think about the long term. We've got to think about generation 2 and generation 3 and generation 4, and I've got clients in generation 5. So you actually have to think about, well, I had this set up for a reason at the time. I might not recall what that reason was. Someone's telling me I need to have a company. Does that suit everything I'm planning to do with my business? That can be advice from your accountant, as well as advice from your financial planner, as well as advice from your lawyer. because when you are dealing with these structures in the longer term, as I say, teamwork approach, no one who specialises can really be across every single issue. So it should be a teamwork exercise when you're looking at how the business should be structured or how it should be restructured and what the risks are. Because the long-term risks can be far more expensive in 10 years' time than the shorter-term risks were. So it's important to look at the long-term and the entire global approach when you're looking at this. Because as I say, I had a building company a couple of years ago, which was doing really, really well at that time, but dad and son owned the shares in individual names. And there was a problem as far as dad's new spouse was concerned, so they wanted to move these shares to a trust. Company shares had been issued for $1, company was now worth $20 million. That's a big tax issue to deal with, which could have been structured slightly differently at the start. So thinking about what you might have to do with the business long term, other than just what you might have to do year by year, is always important when you're thinking about your structures, particularly establishment or restructure.
Appreciate that. And I've got a couple of things down here, Kylie, which I'd suggest anyone does themselves right now is get that entity diagram, ask your accountant to draw it up for you so that you can get your head around it. Have a discussion with your accountant about this. You know, you've heard the podcast. There's some changes in trust cases. If they're a little bit vague or don't know too much about it, which it's a lot to keep up with, is have a listen, get them to listen to the podcast and then have the conversation with them. And I think if anyone's vague or doesn't really know the answers or is a bit dismissive, well, maybe get a second opinion if you're really concerned.
And ask within those flowcharts, because as we said, the flowcharts are important. Ask for them to show not just the structures, but who controls what. So where the control of those structures sit, and are there any loans between them? You know, are there any loans sitting out there? Because most flowcharts can show all of that, even if it's one flowchart for control and one for loans, etc. But that can allow people to fairly quickly identify, oh, I didn't realise that was there. In a very simple overview, you can then say, I didn't realise that was there, I need to find out why.
And does it need to be cleaned up?
Yeah, it may be fine, but it might not be. Yeah.
Excellent. Well, look, Kylie, that's incredibly information dense.
It's actually a little high level, but it's if it gets people to start to think about what they've got and do they need to look at it, then it's achieved something.
It is, yeah. And look, I think there's a lot of younger people that are coming in as part of a succession and starting to take over the family business. And I think this is where they need to start in a lot of cases. This is part of it, should be part of the apprenticeship, is to understand how the business entities work and what the risks are, because eventually you're going to take over this business, the appropriate entities, and there's a massive number of landmines in there that need to be cleaned up before you do take over with beneficiary loans.
And sometimes they're an easy fix. You know, sometimes it is literally, like I said, with partnerships. Every now and then the partnership, the financials, everything's clean. It's just there's no partnership agreement. So if someone passes away, we might have a problem. So it can be something very simple. But if you don't have it and there's a problem down the track, it's no longer simple.
Exactly. And that's a great point for the younger people. I mean, I had a discussion many years ago with a young guy who was part of a succession. He said, I just want to understand how everything's structured so I know what the hell's going on behind the scenes. I can get my head around it. And it took him a few years to do it, but he got it eventually and it made perfect sense. And you're never going to get it overnight because most people's situations are complex when it comes to the tax and accounting. And
it might not be perfect, as we said at the start, if it hasn't been reviewed for a long time. I've had one recently where it hadn't been reviewed for 25 years. If it hasn't been reviewed for a long time, it might not suit what you're now doing with the business, whether that's someone else coming into it or not. If it's been a while since it's been looked at, it needs to be looked at.
And you might head off some problems in succession 5 to 10 years down the track as well. Tidy it up on
Absolutely.
the time. So thanks very much for that, Kylie. That's been really informative. How can people get in contact with you if they need to?
Well, I'm fairly easily Googleable, because people love Google, but generally just shoot me an email. Happy to have a chat. We will have an initial chat with anyone who's got concerns at no charge, just to get an idea of whether they need help or not.
No, perfect. And I'll put those in the show notes if anyone's looking for it. So thank you, Kylie. It's been fantastic. And I look forward to the next one we do.
Great to talk to you again, Ben.
As I said to Kylie, this has been an information dense podcast, so I'm just going to highlight a couple of areas which I think are worth noting. The first one is learn about your structures, have the conversation with your accountant, and also see if you can get hold of an entity diagram so you can understand how the entities are all flowing together and who's in control of the key positions in those trusts. So for companies, it's directors and shareholders. For trusts, it's appointers, trustee, beneficiaries, etc. Number 2, if you've got a partnership in any way, shape or form, you need a partnership agreement. Critical that you have one of those in place. And as Kylie said, it's very simple and easy. Number 3, beneficiary loans in trusts. If you've got loans in your trusts, have the conversation with your accountant and work out, do they need to be there or are there some problems with those? Number 4, trust deeds. Make sure you get your trust deed reviewed and you understand what's in the trust deed, because the trust deed is the legal rule book for what you can actually do. And you need to remember, as a trustee, or if you control the companies that's the trustee, you have a fiduciary obligation, which is a legal obligation to do the right thing or the right legal and tax thing. And if you don't, you're personally liable. Next, do your tax planning with due care, especially when deciding who to distribute to in your trusts. That's a really important point. When it comes to reviewing your trusts, make sure you don't just think about these issues in trusts. Make sure you consider all the factors in your unique situation, because it might be that there's some risks in the trust, but the benefits override some other part of your situation which needs to be reviewed. And finally, what suits one family doesn't suit everyone. So be careful who you listen to. The number of times I've had people say to me, oh, my brother does this, or my parents do this, or my auntie does that. Just because they use a company or a partnership or a trust doesn't mean that you should. And there's a whole lot of reasons and complexities that you don't know about in their situation, which might make one strategy appropriate for them and not appropriate for you. So be careful who you listen to and get advice on that. Now, I appreciate all the feedback I've been getting recently, which has just been amazing. And if there's any topics you'd like to hear more about, just drop me an email, ben@thefinancialbloke.com.au. I always welcome both positive and constructive feedback about the podcast, because we're always trying to make it better. Now, that's it for today. I'll see you in 2 weeks' time.